Well, good evening. This is the Leadership Essential session on Constitution and Canons. Thank you all for joining us. My name is Mark Galus, and I am the Chancellor of the Diocese. David?
Yep, and I am David Powell. I am the Associate Chancellor of the Diocese.
As many of you know, David was my predecessor's Chancellor and was gracious enough to stick around as Associate Chancellor to help me find my way, and I'm certainly grateful for that. Briefly, for those of you who might not be familiar with the office of Chancellor, you might be asking, well, what exactly does the Chancellor do? The Chancellor is the chief legal officer of the diocese, nominated by the bishop, elected by the convention to a 3-year term, as is the Associate Chancellor. We are volunteers, so we are not members of the bishop's staff. Do we have any lawyers with us by chance? Any show of hands? I was the Associate Chancellor last year, and one of the first questions that I asked David when I got the job was, well, who is our client? And as with most all legal matters, the answer was, well, it depends. The short answer is it's the diocese. We represent the diocese, sort of a general counsel type for the diocese. But the diocese is made up of a lot of components and a lot of constituents. So we provide advice to the bishop, to the standing committee, diocesan council, various committees as well. But it also goes towards churches and rectors and vestries. That's part of our charge within the Constitution and Canons. We will, provide legal advice and guidance to those who seek it out. Our goal is to provide as much of our work pro bono as possible. There are going to be times where there's a matter that's way above our pay grade that we might need to engage outside counsel, or if we have a church that needs some help and we really can't do it, we'll find a way to hook them up with a lawyer in their community so that they can have counsel. We are undertaking a project, the Episcopal Lawyers Network, where we are seeking Episcopal lawyers in the diocese to put on a list to have ready access if someone needs a real estate lawyer in Branson or needs a criminal attorney in Joplin or whatever the case may be. We want to be able to have a list available to churches in the diocese to provide that assistance. So that is a project that we're working on. Let me give you a little roadmap for tonight. David is going to lead us through a PowerPoint presentation. We're going to first cover the national Constitution and Canons, and then talk about the diocesan Constitution and Canons, including some areas where there might be need for possible revision or updating. If we have time at the end, David also has a parliamentary procedure cheat sheet that he's provided to the last couple of conventions that's come in very, very handy. We encourage your questions. If at any point you have a question, feel free to put it in the chat. I'm going to be monitoring that. And then hopefully we also will have a little time at the end for questions as well. So with that, I will turn it over to David.
Okay, thank you, Mark. And thanks everybody for joining us this evening. What we're talking about tonight really is kind of almost a private body of law. So in terms of how we organize our affairs, both as a national church, as a diocese, and even as parishes, there are kind of two bodies of law. There's the kind of civil body of law that we all know about, which is what Mark and I do on a daily basis in terms of our practice. But in addition to that, there's a private body of law, which is the rules that we've developed as a denomination and as a diocese for running our affairs. And those are contained in the constitutions and canons of the national church and the constitutions and canons of the diocese. And so that's what we're going to be talking about today, kind of giving you a kind of an overview of what's in those different bodies of law and what they speak to. And it's sort of a finding aid in terms of if you're curious or you want to learn more. It's also how we go about problem solving. If a question comes up, we sort of decide, is it on the civil side of the house or is it on the ecclesiastical side of the house? And what's the body of law that's going to control what we do, that's going to guide us? Now, I'll say at the outset the judge I clerked for out of law school used to say there were the three learned professions, and they were the medicine, the clergy, and the law. And particularly if you get lawyers and clergy together, there's a wealth of rules that can be developed. And what you'll discover is we've done that. The Episcopal Church in America has been blessed by having any number of scholarly clergy and scholarly lawyers who've devoted time to working on these issues and developing kind of rules and guidelines for us. And that's what we're going to be talking about it. What you'll also discover is, as so often the case with the smart people, every time they come up with an issue, they can come up with a rule to address it, and they'll write it down. And so over time, the number of rules you have, the number of laws you have can expand. And so that's sort of where we're at now. There are a number of different areas that are covered by the constitutions and canons. We need all of them, but you don't have to know all of them or don't have to have all of them at your fingertips. So this will sort of give you a finding aid. I'll point out that there are a number of clergy already on this call, also people who have been experienced on vestries and on standing committees. So the kind of years experience on this meeting dealing with these kinds of issues is quite broad, and I hope this will be a conversation. So if anyone has a question or a comment, please feel free to put it in the chat or raise your hand, because it'd be nice to make this something of a conversation. And I also know that, my coverage and Mark's coverage of some of these topics may be general, and a number of you, given the depth of background and experience, may have encountered particular issues. It might be helpful for us to learn about. So with that, I'm going to go to the PowerPoint and get started with that, if I can do this correctly. And what I need to do is share screen. So, okay. All right. So hopefully now you're seeing the, hang on. I've frozen. Got it.
Looking good here.
Okay, what are you seeing?
Convention procedure and rules of order.
Okay, so I'm getting there. Sorry, I I glitched. So give me just 1 second. I'll get this back up. I had it all ready to go. It was great, and now obviously I've thrown it off. Okay. Oh, I know what I need to do. I apologize, everyone. Okay, so as I said, what we're getting ready to discuss is going to be we'll start with the national constitutions and canons. Okay, now can you see it? Okay, got it. All right. So we've already done the introductions. Mark and I are both lawyers. I do want to call out to our colleague, Stephen Ott, who's the Chancellor of the Episcopal Diocese of Michigan. There is a Chancellors Network that Mark and I and all the Episcopal Chancellors are a part of. It's very useful because it allows all of us chancellors to have a common sounding board for issues. So frequently what will happen is if a question comes up, we will consult the constitutions and canons, but we'll also reach out to our fellow chancellors to see if any of them have encountered the issue before. And so there is a kind of a real wealth and depth of knowledge out there that we can access, which is quite helpful. So some of these issues we're talking about is the what's called the discipline of the church. It's the rules that we follow. It's the constitutions, canons, the rubrics and ordinal, and the Book of Common Prayer. And the goal of the canons and the constitutions isn't to fence us in, but it's to provide a general guideline and a general way of organizing ourselves. So it's just not chaos. So we have a common frame of reference, a common understanding of how we're going to proceed, and that allows us, as the rule says, to kind of interact with each other with dignity and thoughtfulness. So in the Diocese of West Missouri, we are incorporated as a civil corporation. It provides that we hold ecclesiastical allegiance to the Episcopal Church. That means we have agreed that we are going to be bound by the constitutions and canons of the national church, and our local constitutions and canons have to abide by the national canons and the national constitution. So that's how we fit within it. We have a diocesan council, and that is prescribed by the national church in terms of how dioceses are going to organize themselves. It provides that the diocesan council has the power to acquire, hold, and convey property. And that holding property is important because that is, unfortunately, we've had some instances where, churches will pull away from their existing church, from the discipline of the ecclesiastical allegiance to the national church. And when they do that, they can't take their property with them because the property is held by the diocese in trust. And that's an important thing because, generations of Episcopalians have, given their time and treasure to build up our infrastructure. And it's appropriate that it stay with us, stay with our church, and that we shepherd it and we are good stewards of it. And so that's part of the process. So let me quickly talk about how you talk about constitutions and canons. The canons are typically the Constitution is sort of the big structure for both the national church and for the diocese. The canons are more sort of the nuts and bolts rules, and they typically correspond to the different sections of the Constitution. And so frequently you reference them by title and by number and then by section. So for instance, if you're referring to a particular canon, you refer to it as canon, big Roman numeral 4, canon 4, section 1, as you see on this slide. So that's just kind of the general way we cite to things that when we're referring to them. You'll be familiar with that from the resolutions that you see at convention, which when they refer to a change to a constitution or canons, it's this citation that we have. So all of this is going to be kind of old hat to a lot of you. The general Constitution establishes that we are the Protestant Episcopal Church in the United States of America, otherwise known as the Episcopal Church. It establishes that we're part of the Anglican Communion. So it shows that we are, a constituent in communion with the See in Canterbury, and that we are, embodying and upholding our faith as it's found in the Book of Common Prayer. And I always look at the Book of Common Prayer when I'm sitting in the pew of church, and I like to turn to the front page, which shows that it was, first adopted in 1789, which is the same year that the U.S. Constitution was adopted, and that's part of the process. We broke away from from England, both politically and religiously, but we then promptly adopted, some of the same laws and the same religious practices, and that's an important continuation in our tradition. So let me kind of jump in. As Mark said, we're just going to kind of quickly run through the big sections of what's in the National Constitution. So there are 12 articles in the National Constitution. They're breaking them down by particular categories of information. So, Article 1 refers to the General Convention, how it will be run, who will be involved. Article 2 addresses bishops. Article 3 is bishops in consecrated and foreign lands, because there are a number of kind of foreign lands that are part of our church and that hold allegiance to our particular brand of the Anglican Communion. Article 4 addresses standing committees, both the standing committee of the National Church, and if memory serves, also the standing committees for the individual dioceses. Article 5 is on the admission of new dioceses. Article 4 is of the construction of missionary dioceses. So what you will see is a lot of times with constitutions, you're planning ahead, you're figuring out how people are going to enter into your organization and how it might be expanded. In addition to that, there are going to be articles addressing, how we're going to divide ourselves up into provinces. There are pure ecclesiastical issues addressing the requirements for ordination. Article 9 addresses courts, and those are the courts of the national church that address disputes with bishops and other disputes of that kind. Article 10 addresses the Book of Common Prayer and our dedication to that as a center of our religious practice. Article 11 is the one that sometimes comes into play when we're looking at our issues. It addresses dioceses and missionary dioceses and how those will be constructed and run. Again, what you will see a lot of times in both the constitutions and canons is a question of how can we amend this document? And so the National Constitution has a process for amendment in Article 12. We also have a process for amendment. And I'll just quickly touch on that. The national church and as it is in our own diocese, it's usually a kind of a lengthy process to amend the Constitution, because you don't want that to be something that's done willy-nilly. It needs to be done with due consideration. So for instance, in our diocese, it requires a vote of 2 conventions to amend our Constitution. A canon can be changed with a vote of a single convention, but the intent of that is that the Constitution as our governing document, like the National Constitution, needs to be something that isn't changed quickly and without due deliberation, which is why it typically takes 2 conventions to make that type of change. So the Constitution kind of covers these big ticket items, how we're going to structure ourselves, how we're going to organize ourselves, how we're going to go about organizing our religious practice with the Book of Common Prayer, how we're going to call clergy through ordination, and those sorts of things. The next level down in terms of legal analysis are the canons of the General Convention. And the canons have 5 major sections, which are also called titles, and the titles also govern aspects of our organization as a national church. So Title 1 is organization and administration. Title 2 covers worship. Title 3 is ministry. Title 4 is ecclesiastical discipline, which I will cover in a bit more detail. And then Title 5 are kind of the catch-all provisions. So Within Title I, it discusses how we're going to be organized and how administer the church. It specifies that our structure will be a general convention of the national church, which then devolves down to the diocese, and from the diocese down to the parish and congregation level. The church itself is known as the Domestic and Foreign Missionary Society, and all of the dioceses are members of it. This title governs such issues as how we're going to maintain the archives of the national church, the business methods the national church is going to use to run church affairs. There are provisions relating to parishes and congregations, also rules relating to parish vestries and how they are intended to be organized and structured. And then there are provisions relating to clergy and congregations who are already in existence, but want to change their affiliation and join our Episcopal Church. In addition to that, Title I has a whole number of regulations regarding the laity. It refers to who's going to be considered a baptized member, who are adult members, how members are confirmed and received, how communicants will be brought into the church, and adult communicants, what the criteria are for a communicant in good standing, and then other issues relating to rights of the laity, really hard issues like, when do we, effectively excommunicate somebody? What are the rules for making a serious determination that somebody will be refused Holy Communion in our church, which is such a serious and significant issue. Also eligibility for communion, and then the fiduciary responsibility we have. There are other issues that will come up. There are rules relating in Title I relating to marriage and the matrimony canons. It requires us to, comply with state law relating to marriage. We are also required to comply with canon law with respect to marriage. It addresses the criteria for a marriage that, one person must be baptized and a member of the faith. There must be 2 witnesses. There must be a declaration of intent, and that the clergy may decline to solemnize the marriage. And this is an interesting issue, and I'll just touch on this briefly because it shows the distinction between civil law and ecclesiastical law as it exists in the constitutions and canons. Because when you're married, it's a civil contract, and it's also it's a civil contract which is licensed by the state, but it is also a kind of a spiritual union that's blessed by the church. And I've always considered those are 2 separate things, and those are 2 separate processes, and both need to be honored when we go about our work. And so to give you a quick example, one of our fellow chancellors, who's now since retired, was a state court judge in New York State. And in addition to being chancellor and a state court judge, he also, served in his church as a minister, as a lay, officiant. So this couple is getting married. They had been divorced, and the requirement was that they had to get the approval of the bishop before they could get married. So here they are at the ceremony. They're all set to go, and suddenly they realize that they had neglected to get approval from the bishop, but they're ready to have the ceremony. What to do? Because the priest quite rightly said, the rule is you have to get, the blessing of the bishop to get married, and I'm not authorized to perform the marriage ceremony. Luckily, our fellow chancellor was there and was a state court judge and authorized to administer civil unions. And so he actually stepped out, took off his vestments, put on his judicial robes, came back out, performed a civil marriage ceremony, and they went on with the other trappings of the ceremony. But it shows that, you know, you have to acknowledge the existence both of civil law and ecclesiastical law in our governance. So that was Title I. Title II is the one that our clergy will be far more familiar with than I am, but it governs our worship practices. It specifies that we're going to hold worships on Sunday. It identifies the particular translations of the Bible that are recognized by our church. It designates the Book of Common Prayer that is standard, which is the 1979. That's the one we've got. It's not like the English royal family, where if your mom is the head of the Church of England, you can pick a different Book of Common Prayer for your wedding service. We've just got 1979. Interestingly enough, and I think this is a nice that, it addresses music as part of our religious practice, and calls out that it's a duty of the clergy to provide music as kind of part of our faith practice, which I think is neat and one of the great traditions of our church. It talks about how we dedicate and consecrate churches. It also provides how we, decommission churches, which unfortunately sometimes we have to do. So it specifies how that's going to be done. In terms of Title III, which talks about ministry, it identifies us as kind of a ministry of the baptized. It provides that there shall be commissions on ministry. It gives direction about the discernment process. It specifies who will be in the ordained ministry as being deacons, priests, and bishops. And there are canons on the life and work of each of those orders. Title III also specifies the different religious orders that the National Church recognizes, and it provides governance instruction relating to the examination of chaplains and the transition ministries. So now let me turn to Title IV, which is ecclesiastical discipline. And I think this is kind of an important topic. So I'll go into this in just a little bit more depth because this is an important part about how we govern ourselves. So Title IV addresses complaints against clergy. And was recognized from the early days of the church that there was a need to have a discipline for the clergy, a process by which people could seek relief or advice if they got crosswise with their clergy. And it's important for us to have that process. And as I'll explain later, part of that process is traditionally there's been a kind of a judicial type of process, and there was a prosecutor under canon law that's the church attorney. At one time I held that position. The nice part about the Episcopal Church is being church attorney, it's sort of like being the Maytag repairman. You rarely had anything at all to do, which is a tribute to our fine clergy. Touch wood, we have avoided many of the problems of some of our fellow Christian churches, and that's all to the good, but we need to have the ability to make sure that people are heard if they have problems. So Title IV applies to the ordained clergy. So we don't have a process where you can complain that the person in the next pew over is an annoyance and something has to be done. We do not have, nor do I contend we need a formal process to cover, internecine parishioner disputes. And hopefully our wonderful clergy can help guide people through that. But so Title IV is addressed to the clergy who have taken vows and been ordained. So that is who it's addressing. It provides grounds for discipline, and it is addressed to issues where they have gotten crosswise with what is expected of someone in their order. I will point out that there is an important qualifier to discipline, that it needs to be material and substantial or of clear and weighty importance to the ministry of the church. And so, it needs to be something truly significant in the life of the parish, the life of the parishioner, the life of the clergy. It is not designed to be, kind of a minor sort of disputes.
David, I see that Larry Aaron has his hand up.
Oh, go. Yes, Larry.
Thank you, Mark. This is very relevant to our diocese, obviously, in terms of our history. Could you please give some examples of, material seriousness? So we're not talking about just small things, but what would be some examples that are of significance that you would employ this title, this procedure? And you don't have to use examples. From
no. I'm not going to use any sort of real examples. And so the important thing the classic example, the worst case scenario is let's say, if a clergy was committing sexual harassment or, acting with racial animus towards parishioner, or, something of those kinds, or, was, excommunicating somebody from the church, without cause and without following the wrong, that process. If they are truly acting as a law unto themselves and harming a parishioner, that's the type of thing. But the bottom line is, in our diocese, and it's part of the system, which I'll talk about, we have an intake officer. And I think we always want someone who feels aggrieved to reach out to the intake officer with their complaint, so it can be addressed appropriately. And so that leads, right into the slide that's up right now, which is, for many years, the disciplinary process was really truly lawyer driven, based on the civil law, litigation of the type that Mark and I do, and had, multiple layers of due process protection, all of which were important, but it failed to address, in some ways, the appropriate kind of ecumenical issues of trying to seek reconciliation and healing, and provide opportunities for informal resolution. And so that's why I don't want anyone to be dissuaded from raising an issue with the intake officer, because, we can go through, if necessary, we certainly will go all the way through a full process for a full disciplinary proceeding. But even if it's a matter that might be short of something that really falls within Title IV, we still have the ability and I think the need to address these issues and seek reconciliation and healing. And so even if something doesn't rise to the level of a full Title IV proceeding, it's still helpful, I think, that the intake officer is there as a sounding board It allows someone to find someone else to talk to, and it would provide us for an opportunity for reconciliation and healing, and to see what we can do to address it. So that's where I think this new process is helpful in terms of it's not solely focused on reconciliation and healing, but it embraces that. And I think that's important, that particularly for the laity, if they have issues, that they feel comfortable raising them and doing them, do it so that we can do that correctly.
We're very fortunate in that Deacon Donna Stanford is our intake officer. Not only is she just gifted, but and obviously an experienced deacon, but she's also an attorney. And
Yeah.
in our case, it's really good that she's a woman. I've often thought that whoever originally made that appointment was very wise.
Yes, and she's very wise. And you know, my thought always is, you know, as this mentions, there's a lot of due process involved in terms of how these proceedings are run and arranged. But at the first instance, you know, at Reverend Donna's instance as the intake officer, you know, when we first get a complaint, you know, and this happened when I was a church attorney. You know, if the intake officer calls me and says, you know, there's been a complaint, my first question always is, you know, okay, we have to assume in the very first instance that everything the victim is saying is true, and are they safe? So, you know, I want to make sure that the victim is the complainant, I'll put it that way, that the complainant is safe and taken care of, and then we can turn back to you know, the due process for the clergy member involved. And that's not to say that we're, you know, switching sides. We just need to make sure that, you know, everyone is protected as part of that process, and everyone is safe. And I'm, you know, always been very heartened that those who are involved in the disciplinary procedure at the diocese are, you know, incredibly diligent and committed, and wise and thoughtful. And I, you know, touch wood, I think it's always, in the few instances we've had to take action, it's always, I think, been handled very well. So let me talk about the people involved in Title IV proceedings, and I'll kind of quickly go through this, but Father Larry has pointed out the key player is the intake officer, who makes an initial review of any complaint. You know, she has the ability to decide it doesn't rise to the level of a Title IV proceeding, but if she thinks it does, she can refer it to the church attorney for further investigation. There's also a reference panel that consists of the president of the disciplinary board, the intake officer, and the bishop diocesan, to determine the next step if it's going to proceed beyond the intake officer. And then if it goes to the disciplinary board, which will be holding sort of a court proceeding, there's a requirement that there'll be 7 members. The diocese will determine how they are selected. The clergy will hold a 1-member majority on the disciplinary board, and members are chosen at random to serve on conference panels and hearing panels for particular matters. So conference panels are 1 to 3 members of the disciplinary board. They will conduct informal conversational proceedings to try and resolve complaints. If that doesn't work or is not appropriate, it can proceed to a hearing panel made up of 3 members of the disciplinary board that will conduct a formal trial of the complaint. The outcome of that trial is not is not final, because there can be what's called a provincial court of review, which will serve as an appellate court if one side or the other believes that there's been some sort of error or miscarriage of justice in terms of how the the proceedings have been run and how they resulted. As I mentioned, the church attorney is a licensed attorney who is assigned to represent the church in Title IV proceedings. So in this instance, they are a licensed attorney in the sense that they are trained and they're licensed within their state. But in the purpose of these proceedings, it's not a civil court, it's really an ecclesiastical court. And so the law of the land or the law to be followed is the constitutions and canons that are relevant. And I'll skip. I'll just point out that the clergy who are complained of are entitled to advisors, and they can have legal counsel if they choose. There can also be advisors who can support and assist the complainant in moving forward with a question. We have the ability to appoint investigators to conduct investigations, and that can be anyone from a retired FBI agent who is experienced with a particular type of issue to help us get to the bottom of that. And that can be helpful because you have somebody who's experienced with conducting interviews of witnesses and doing other kinds of investigation. And then we also have the ability to have a conciliator appointed who will assist in seeking resolution of the matter, short of the full trial or after a full trial. So again, it is this process where we're seeking kind of to discern the best way forward for all parties. And if that's, short of a trial, short of a formal proceeding, we have the ability to do that. So that's with kind of Title IV. Title V are the general provisions, which address the kinds of things you would think of as being general, which is, well, how are the canons enacted? How are they amended? How are they repealed? There are matters of terminology, how quorum is counted, how vacancies are handled, those sorts of things, similar to what we have in our own kind of constitutions and canons. And there are a number of resources you can find. There are links to the national constitutions and canons on our own website, and then the General Convention also has publications of the constitutions and canons. And if memory serves, I believe they've been at least translated into Spanish, and I'm not sure about if we have other languages or what they are, but there are other versions. So let me jump to kind of our constitution for our diocese. It establishes that we were originally formed in 1889. Our civil corporation dates back to 1920. We have a number of articles within our constitution. Article 1 is the basic one that establishes that we hold allegiance to the National Episcopal Church. Article 2 specifies the name of the diocese and how membership will be determined. Article 3 designates the officers of the diocese, which will be the bishop, a bishop coadjutor, and suffragan bishops, if any. We have a treasurer, a secretary, a chancellor, and a registrar. And there is provision for other officers, such as the associate chancellor, like myself. Article 4 is the part of the Constitution that governs how the officers will be elected. Then Article 6 specifies the powers of the diocesan convention. And that really is the power in the diocese in the terms of both the civil corporation and the broader kind of ecclesiastical decision-making body. So The convention kind of holds the power and then effectively delegates it to the diocesan council between conventions. So the diocesan council can act essentially with the power of the convention between conventions, although obviously it can't change the canons, it can't change the Constitution, it doesn't have those kinds of broad powers. And then within our own structure, the Diocesan Council has created an executive committee, which has the capacity to act between meetings of the meetings of the Diocesan Council. Although in this day and age, because we've now changed the corporate structure of the diocese, we have the ability to hold virtual meetings of the Diocesan Council. So, on a weighty issue, it will be possible to, stand up an emergency meeting in the Diocesan Council rather than simply leaving it to the executive committee to take action. So I'll run through these other articles address how the convention is going to be empowered, who the officers of the convention are going to be. It addresses weighty issues such as the membership of the convention, who's entitled to vote, the requirements for assessment, the requirements for meeting the assessment in order to vote, or how that has to be waived. There are requirements for meetings, when they're going to take place and where. We've since been able to change the rules to allow us to hold both virtual conventions and half-day conventions, which have been important in terms of both addressing particular issues such as the budget, if there was a need for kind of a mid-year convention, because we thought the budget was going to be difficult, we wanted to take a second look at it, or to have a short convention such as we had to adopt the rules that allowed us to hold a virtual convention during COVID. And then Article 10 provides for rules relating to the transaction of the convention's business. Article 11 addresses the admission of new parishes and congregations and how those are going to be, what you have to do in order to be admitted as a new parish or congregation, and it defines those. And, there have been a number of questions over time about how should parishes and congregations be defined, and missions be defined. Some of that is contained within the Constitution itself, some in the canons, and those issues kind of touch on both, and they address how we will organize ourselves and what needs to be done there. Article 12, is one I don't think we've ever had to deal with, which is the expulsion, suspension, or dissolution of a parish or congregation. Some parishes have merged, which has been beneficial for both, and that can touch on that article as well. I'll simply point out that, our Constitution does have a tie to civil law, in the sense that as written, the members of the convention are members of the civil corporation, which is part of the structure. It provides for the diocesan council, and that it's empowered to exercise the power of the convention between sittings of the convention. It addresses the membership of the civil corporation and the diocesan council, which currently the voting members are the bishop, the secretary, the treasurer, the chancellor. There are other sort of ex officio members, the deaneries. There are some that are appointed by the bishop, And typically the bishop, and then in addition to those, there are 8 lay persons who are elected and 4 clergy who are elected. Traditionally, the a bishop's ability to appoint members to the diocesan council has served 2 purposes. One is it does make sense that you want a bishop to, have some influence in the governing body of the church throughout the year. And the other is, and this has been a longstanding tradition in our diocese, the bishops have used their power of appointment to balance out the diocesan council, both geographically and in terms of representation. So, I've always thought that the power of appointment to the diocesan council is important because you need to have some way for, hopefully the wise person you've called to be your bishop to make sure that that it truly is a representative body. And in some ways, it's a representative body, but not in the sense of like the houses of Congress, where, if we had a truly representative body, it would be unwieldy because we need at least one representative from each of the parishes and congregations, and that would just be too large. So you have to have kind of a smaller group, and then the ability to kind of address representation within the diocese. I've mentioned the executive committee of the diocesan council was established by resolution. So it essentially establishes that the power of the diocesan council is delegated to the executive committee, which I've not been on in a while, but the executive committee, if memory serves, is the bishop, the treasurer, the secretary, the chancellor, the chairman of the diocesan council, the president of the diocesan council, and I believe there's one other elected member of the council. It forms the executive committee. So it is a broad representation of the leadership of the diocese and leadership of the diocesan council. In addition to obviously the diocesan council, it's very important. We have a standing committee that's provided for in the national canons. Article 14 provides for our standing committee and establishes that it will be 4 priests and 4 laypersons. They are to serve as in my view, a cabinet to the bishop, to serve as a council of advice. It serves as the ecclesiastical authority in the bishop's absence, which means that they can take the sorts of decisions that the bishop would make in terms of calling a convention and taking other actions that a bishop would take on behalf of the diocese. So both of our so within Missouri, there's a diocese on the eastern side of the state and our diocese on the western side. Both of our dioceses have a separate diocesan council and a separate standing committee. The Diocese of Kansas has combined those, and they essentially meet, and I think they probably have bifurcated meetings for when they have to do their standing committee activities and when they do their kind of civil diocesan council governance activities. Off the cuff, I think our system works well because there really are, the standing committee really addresses issues with respect to ordination, which is a separate task, a separate duty from running the civil corporation to the diocesan council. It also provides an additional group of voices who can advise the bishop. So I think that can be helpful. In some ways, though, I think it's helpful for the diocesan council and the standing committee to have some combined meetings so that they have some sense of the issues, because otherwise you have a standing committee that may be kind of unaware of all the, the budgetary issues that the diocesan council is fretting over, and you kind of have to have both. You have to understand really how the diocese is being run, both from an ecclesiastical standpoint and from a kind of civil governance and budgeting standpoint.
David, if I could jump in for a second, one of the ways that's happening is that the president of the standing committee is a member of diocesan council, and the bishop frequently attends. Has been invited by standing committee to attend their meetings, and I think the bishop is using the standing committee as it was intended, as sort of a cabinet or whatever you'd like to call it, getting advice from the standing committee as they see fit. So that's been a change from the past few years into how those bodies have interacted.
Yeah,
I think additionally, they meet together several times a year to address that isolation that you're referring to, David. So it's good to see that the structure is actually evolving according to need.
Yeah, it's nice to have both entities. You just don't want to get in a situation where they're siloed, and we've thankfully we're avoiding that. And I agree with Mark. It's working the way it should and the way it's intended.
We did have a joint retreat. We had a joint retreat earlier in the year, council and standing committee. And as I said, the bishop is actively involved and really leaning into that advice part, getting advice from the standing committee. So that's really worked out well.
Yeah. So then within our Constitution, there are some other issues, how we're going to elect deputies to the General Convention, how we designate the cathedral. I'll kind of quickly run through our canons, so you're aware of how they're structured. The Canon 1 defines who are canonically resident clergy. Canon 2 specifies the lay delegates and how they will be selected, and the congregation committees, and also specifies the youth delegates. The canons also specify the duties of officers to the diocese. So the secretary, the treasurer, the chancellor, the registrar, all their duties are specified in the canons. The treasurer's canon, in addition to the canon related to the treasurer, there's also a canon that specifies what our fiscal year will be. The chancellors, to give you a flavor of it, the chancellor's canon, specifies that a canon has that the chancellor has seat, voice, and vote on the diocesan council. It also specifies that the chancellor will be required to attend the standing committee on their invitation. So it specifies that the chancellor's office will have a role in advising the standing committee when they request it. The canons also provide our kind of organizational structure. It specifies the deaneries, how the deaneries are going to be defined. Again, it specifies the membership of the diocesan council, specifies how we'll handle vacancies, the officers of the diocesan council, departments, bylaws, the meetings, the records custodians, what constitutes a quorum, all those kinds of nuts and bolts issues for which you need rules are specified in those canons. Our canons also specify that they're going to be diocesan and parish registered. It defines the congregations. It defines parishes. And this is one of those issues where the canons, as they are currently structured, are really hark back to a mid 21st century, called mid 20th century model for a parish, which was you've got a building, you've got a full-time priest, you've got proven financial strength and a record of having at least making your diocesan apportionment for 2 years. All of that, makes a great deal of sense, but in the modern era, in the 21st century, you can be a viable church, maybe without a full-time priest. We have more bivocational priests. We have, you can envision having a strong church without its own building. And so there's some question about, occasionally it comes up about how do we address that? And that is something that's, in the canons and something to consider.
David, this is actually an area where Constitution Canons is going to focus on. I mentioned at the start, there are a number of things that, the bishop and others have asked us to take a look at. And this is one of those areas, what is a parish? What is a congregation? I know the term often used for congregation is mission instead of congregation. We have approximately 16 missions or congregations and 31 parishes in the diocese, but we have some parishes that probably ought to be congregations and some congregations that probably ought to be parishes. And the reason it matters in a large extent is that, parishes are fairly autonomous. They can incorporate, they have a rector, a vestry on its own property, within limits. But the congregations are somewhat wards of the diocese. They can't incorporate without permission. The bishop is actually the rector of those churches. There's a bishop's committee, not a vestry, and the property is owned by the diocese. So there is this one of the things we're going to look at is how are we defining parish? How are we defining mission or congregation? Does it make sense for this day and age? As we move forward in the church of the 21st century.
Right. And I think that's right. And I think you want to acknowledge the strength of our churches and their ability to grow. And we need to, think about the best way to do that. So just to kind of round this out, we have also canons that refer to specify how parish meetings are to be held. They define how vestries are to be run. They refer to the custody of the church building. There's a canon that specifies how you can change the name of a parish or congregation. Canon 20 provides rules with respect to rectors and their duties, and again, all of these are sort of kind of long-standing rules that have been developed over time in terms of how we expect, parishes and rectors and to run themselves. There's also a number of canons that I refer to as the best case scenario canons, where we're growing. So we're going to have a cathedral. We're going to have a school for ministry. We'll have a commission on ministry and a board for examining chaplains, because we're hopefully going to get bigger and we're going to need that. There are also specific canons that deal with what's called the kind of worst case scenario, which are dissolution of pastoral relations. What if somebody vacates the rectorate? Assessment reviews, ecclesiastical discipline, which incorporates the Title IV of the general canons and specifies that we're going to have an intake officer and how our disciplinary board is going to operate. And then there is a canon on the discipline of the laity. So then finally, quickly, I'll kind of cover, I know this is getting late, the kind of convention process and then the cheat sheet. In our Constitution, it's a 2-year process to change the Constitution. Amendments are covered in Article 19. So a change to the Constitution has to be approved in the first year. And then the second year, the bishop has to approve it. So the bishop effectively has a veto power. And then in the second year, a majority of both orders voting separately have to approve it. So it can't be a kind of a simple majority in both years. By the second year, after there's been time to think about it, you have to command a majority both of the laity voting separately, and you have to command a majority of the clergy voting separately, which ensures that no one group or the other is going to kind of ram through some change that doesn't serve our whole community. There is a process for repeal of previous articles. Sometimes there are so many changes that it may be necessary to do a wholesale rewrite of a particular article just to make it clear we've restructured some aspect of our organization, and so we're just going to replace it. So we have the ability to do that. Amendments to canons are different. It requires 1 day's notice or a 2/3 vote of the convention to consider a change to the canon, and only a simple majority vote to approve a change. And so one convention can change the canons. And so the canons are meant to be more sort of nuts and bolts where the rubber meets the road. And it makes sense that a single convention can change those. So we have the flexibility to adjust to those kind of changes quickly, or more quickly than a change to the Constitution. We have local rules of order in terms of how we go about handling the business of the convention, and how resolutions will be taken up. They have to be received in writing in advance. Late resolutions are going to require 2/3 of a vote of the convention to hear them. We have rules with respect to how the debate will be conducted. There's speaking limits. No one can be heard more than twice on the same subject. People are technically limited to 10 minutes, but if absolutely everyone was heard for 10 minutes on every subject, we'd never be out of convention. And then the voting members, and then Robert's Rules of Order. And that's supplements our local rules. Robert's Rules of Orders, I'll just quickly tell you, Roberts was a Civil War general, and apparently the most contentious thing he ever saw that probably gave him PTSD was he had a vestry member meeting of his church, which totally devolved into a shouting match, and he decided there has to be a better way. And so he came up with a kind of simple 2-page set of rules for how you conduct meetings to do, motions and amendments and debate. And so naturally, people and lawyers being the way they are, that book has now grown to a massive, thick volume. But it does provide a resource so that if we have a particular question about how to conduct a debate or how to conduct an issue, there is a kind of a set of rules we can rely on. So that's what I had kind of in our general presentation. I'll quickly touch on, if I can make this stop, the kind of cheat sheet. So hopefully now you can see the 2022 convention procedure and rules of order. This is a 2-page document that I try and make sure is that each table at the convention, it sort of provides a cheat sheet. It's designed to boil down, the articles, the canons, and the Robert's Rules of Orders that might apply to particular activities at the convention. So because at convention, you really want people to be able to speak, and you don't want them to be caught unawares by the rules. So really it's the role of the Chancellor's office to try and help people be heard, and help them move to amend, have their voice be heard. It doesn't mean they're going to win, but we just want to make sure people understand the process so they handle it correctly. So For instance, this gives you the rules with respect to resolutions and motions before the convention. It specifies, is there a second needed? Is debate allowed? And it provides the number of votes needed. So for instance, an untimely resolution is going to require a 2/3 vote, whereas a timely resolution, an up or down, is already on the floor and just needs a majority vote. Robert's Rules of Order and our own rules provide rules about how you can control the debates. Is there a way that resolutions or motions don't make it to a vote? You can, stop the motion immediately by postponing it. The original maker can withdraw it. The rules with respect to how you postpone motions, or also, and we've seen this in conventions, there's a way to move that a particular motion be sent to a committee, whether it's a committee of that convention, or sometimes it may be sent to a resolution may be submitted to the Diocesan Council for further consideration. So that this helps to understand those processes. This document also is intended to help people understand how motions are changed. You can divide motions up so that they're taken up in separate pieces rather than all at once, because people may be agreeable to handling one part of a motion, but not all of it. This also specifies how you can change and amend motions, how you can substitute motions because somebody's got a better idea and says, why don't we do something else entirely? And then also how to kill an amendment, which is laid on a table. So some of this is just trying to explain the nomenclature, and the process for under Robert's Rules of Order in our General Convention. I'm also summarizing the process for debate and voting procedures. I want to give people, the standard form in terms of what to say, identifying them yourself, how you address the chair, and then the number of times that you can speak on a particular subject. You'll also see this if you've been to convention is how do we stop? How do you, cut off debate, or how do you limit it? How do you call a question so you can actually, you feel like everybody's been heard? Are we ready to take a vote? There are also ways, to return to a motion or a resolution if something's come up later and you realize that you want the convention to reconsider an action that's already taken. There are also some general Robert's Rules of Orders things about point of order when you have a question about how the process is running and how you raise that. Question of privilege, which is how you say, I can't hear, we need, the sound system needs to be turned up, that sort of thing. How you object to a ruling, from the chair, which is typically the bishop. And then also taking up a point of information where you want to say, okay, I need clarification as to what this motion is actually intended to do, or how it's going to work, or how this amendment is going to work. And then finally, I've kind of summarized the number of votes you're going to need to take particular kinds of action. The kind of regular bare bones things, which are motions and amendments and that sort of thing, which require only a simple majority, or whether it's something extraordinary and it's going to require a 2/3 vote, which would be a change to the bylaws of the corporation, a change to the rules of order, or a change to a business previously adopted. So with that, and I apologize, I've gone a little bit longer, but that's all I've got, and it's kind of a quick overview. I think what you'll find is, hopefully this helps you realize that there are places you can go look if you've got a particular question, but it's also, you're always welcome to send an email to the Chancellor's office, and we are always here to help provide kind of advice and counsel, both in terms of our interpretation as to how the rules work, how the constitutions and canons work, and as a finding aid. And as I said, we also have the ability to reach out to our fellow chancellors to see if you've got a particular question about, how is this done, or how are other dioceses, addressing a particular question. We have the ability to reach out and do research on that.
Thank you, David. Thank you for that presentation. Let me say briefly before we open it up for questions. If anyone's interested in joining the Constitution and Canons Committee, we have plenty of space available. We're happy to have you along. We're going to make it a point to try to do an overhaul of the Constitution and Canons. It might not be for this convention, it might be for next, but we're in that. We're going to go through that process. One of the things is sort of a general cleanup. I think there have been changes made over time in one section, but not in the next section that had something to do with the prior section. And so there's sort of this Frankenstein effect. So that's one thing for us to look at. The parish versus congregation thing we talked about. The bishop wants us to look at appointment power and whether or not there need to be more elected positions than the appointed positions that are there now, to check that balance. The composition of diocesan council, as David pointed out, it's a 25-member body at this point. Is representation appropriate based on where our folks are and what our needs are? One is whether the chancellor ought to be a voting member of diocesan council. For reasons I won't bore you with, there is some issue as to whether the chancellor giving political advice, so to speak, or policy advice versus giving legal advice. And if they intertwine, does the attorney-client privilege work product go away and put the diocese in jeopardy? We're examining that question as well. I've been abstaining from voting at diocesan council for that reason. And lastly, putting together bylaws for the diocesan council. It is essentially the vestry of the diocese, and it needs some rules of order as to how it works. We have some general governing rules, but to make it a little more specific. So those are just some of the projects that we're working on. So if anyone's interested in serving on that committee, you can feel free to reach out. In terms of, there's a question about obligations on time for that committee. In the past, that committee's only met close to convention, but we're going to make it more of a year-round thing. We need to have our initial meeting. The hope was to have this session to get some people interested, perhaps, and then put the committee together to meet later this summer, and then meet on a fairly regular basis, maybe once a quarter or every few months. A lot of the work can be done in the background, in terms of revisions and doing some surveys of what other dioceses are doing. I'm a big believer in bad poets imitate and good poets steal from T.S. Eliot. So there's no reason why we can't see what other folks are doing and maybe go along with that. So time commitment wise, you're looking at maybe a once a quarter meeting, or maybe 5 meetings a year, and then a little work outside of that. So that's what we're working on. Anyone have any questions on the materials? We'll make sure that the slide presentation's available, right, David? We'll get that. Maybe Gary can help us get that out.
Yeah.
And then
it's available if it hasn't gone out already. It may have already gone out.
And then there are links in the chat to the Diocesan Canons, National Canons. I think we can make the cheat sheet available too for folks to have. But are there any questions you have for us before our time is up? Going once. All right. Well, thank you all for taking the time to join us. We've enjoyed our time with you and letting you know more about the Constitution and Canons. It's not exactly exciting material at times, but it's important. It's important to the work that we're all doing for God's church. So thank you all again very much for attending, and I look forward to seeing you all soon.